I'm going to talk about culpable homicide. Culpable homicide, I think, is often kind of the poor relation of murder. Certainly, when I've written on this topic before, I've always thought about murder. How do we define murder? Oh, and anything else will be culpable homicide. But there's a lot in the crime itself. So what I want to look at really is the way it fits into the current structure of homicide in Scotland, and its mental element, which is really what we're supposed to be talking about, but I've moved on from that a bit. When I teach culpable homicide to students, I often talk about it being a sweep-up offence. It catches everything that's not murder, and I was quite interested to see that one of the leading English textbooks has described manslaughter in the same way. When you think about murder and culpable homicide, they share the same actus reus, the destruction of the life of another person. So how are we going to decide what is murder and what is culpable homicide? And often the question will be, does this accused have the mens rea for murder? Culpable homicide comes into the frame if the answer to that question is no. And I think possibly that's carried on if we look at some of the definitions of culpable homicide from the case law. It's quite vague. We have MacDonald's definition of murder is the classic definition, and there's a lot in it, as James has just shown us. What we have on culpable homicide is this statement from Drury, which is well known, which Lord Pentland also showed us at the very beginning of the seminar. It covers the killing of human beings in all circumstances short of murder, where the criminal law attaches a relevant measure of blame to the person who kills. Broadly similar statement from Transco, the gas explosion case where the company was prosecuted. Unlawful killing of a criminal kind in circumstances where the crime does not amount to murder. It can occur in a wide variety of circumstances. And going back to MacDonald as well, again, quite similar. The death of a person is caused or materially accelerated by the improper conduct of another, and the guilt does not come up to the crime of murder. So what are the characteristics that we can take from that of culpable homicide? The accused has killed someone in a way to which some blame attaches. Sometimes they might not have done a lot and the death has resulted. It is always less serious than murder, and it brings with it the full range of sentencing options from an absolute discharge right up to life imprisonment. So at the level of definition, it's very broad. If we also then think about its scope, it does occupy quite a wide territory. So at one end, it sits on the borderline with murder, and I think you see this in a number of the appeal cases, maybe particularly around provocation. The accused has been convicted of murder, and for some reason they are of the view that it should only have been culpable homicide. Just an example of that, which Fiona might talk about later, the case of Hopkinson, which was an Arden Park case. Mr Hopkinson went out armed with a knife to commit a robbery, to help his co-accused to commit a robbery, and she, unbeknown to him, produced another knife and stabbed the victim, and the victim died. And because he had not necessarily conceptualised the plan to carry out the attack in the way that it played out, he ended up with a culpable homicide conviction, but clearly well up at the top end. At the other end, it's on a borderline with deaths which criminal liability does not attach to. I found an English case of an 8-year-old boy who was very sadly killed by a tree branch blown down on a National Trust property. The decision was taken not to prosecute, but his family were very, very much of the view that the National Trust were at fault, and it just kind of sat on that other borderline. In the middle, I think it's generally regarded as more serious than some of the road traffic offences of causing death, in that you can apply a more severe sentence if necessary. So it's very, very broad range of types of behaviour which it covers. The Law Commission asks questions in its discussion paper. Culpable homicide is very broad. Often there is seen to be a value in having that breadth and flexibility, so that's one thing to think about. If we're not going to have that, might we want to have degrees of culpable homicide? We often think about degrees of murder with intentional killing at the top, and falling back to seriously reckless killings, and again, the less serious. So if we're going to draw lines, these are very broad ways into thinking about it, I think. So can you categorise culpable homicide in terms of seriousness? Does the fact that somebody has died always trump everything else? Can you look at the blameworthiness? Huge variety of circumstances, but including what are sometimes called one-punch homicides, where the person might have slapped somebody in the face and they fall and hit their head on the pavement and die. Can you do anything about its proximity to murder, or then are you bringing in an intention to kill, and do you ratchet mercy killings higher up the scale because clearly there is an intention to kill there? So general way into culpable homicide. While, as has just been said of murder, the conviction will always be for culpable homicide generally, it is divided up internally, first of all, into the distinction between voluntary and involuntary forms of the crime. So voluntary culpable homicide, I'm still waiting for this fire alarm. Voluntary culpable homicide is the person may be thought to meet the criteria for murder, but for some reason a culpable homicide conviction is appropriate. Generally that reason will be a successful partial defence of provocation or diminished responsibility. As James touched upon, if jury said that a wicked intention was something different from an intention to kill, then it might have been thought that there was a possible defence of lack of wickedness. That does seem to have been curtailed following El-Sharkizi, as James says, and indeed the cases of Meikle and Gordon, that a wicked intention is really just an intention, and there's no scope for that. So there is a vast literature, particularly on provocation. I don't really want to engage with that at all this morning, but the Law Commission may wish at some point to do that. So the questions really come back to provocation and diminished responsibility. Are they the most suitable defences to knock murder back to culpable homicide in our 21st century society? We could keep them as they are, we could keep them and reform them, or we could have a completely clean slate and ask that question: if we started from scratch, what defences would we now bring forward to make that distinction between the two crimes? I don't really have an answer, but I think it's important to ask that question. Also, culpable homicide sometimes arises because the Crown accepts a plea to culpable homicide, or that just charges culpable homicide in the first place. The fourth edition of Gordon suggests that there are various factors which might move the Crown towards doing that. I think hitherto they have been thought to apply in relation to mercy killings, and perhaps sometimes in relation to a violent partner who kills and who can't really fit the provocation defence properly. So that would then give rise to the question about whether that happens and how we ought to regulate it. Gordon, which is a very recent case of a mercy killing, commentary on that, which Sir Gerald wrote, I believe, suggests that it still remains important to be able to make those big moral judgments around the edges of culpable homicide, and the Crown being able to do that. So moving on from voluntary, we then have involuntary unlawful act, culpable homicide, and involuntary lawful act. Involuntary unlawful act is where effectively now the accused set out to commit the crime of assault, but death resulted from that. And McAngus and Kane, which is a drugs supply case which Lindsay mentioned earlier on, it's fairly clear now that for it to be unlawful act, culpable homicide, the act must be directed against the victim in the way that an assault would be. I mentioned before that this category does include one-punch homicides. They don't seem to have been problematic in Scotland, but there's some literature suggesting that there's a need to make sure that you reconcile disparity between...
That concludes the fire test for today. Thank you for your cooperation.
Let me just sit down now. That's three-stage fire test. So in a one-punch homicide, is there a disparity between the accused culpability for the one punch and the harm, which is the death? And I mean, the thing about everything we're talking about today is that there is always somebody who is lying dead, in this case often on the pavement at the end of the event, and it's balancing up fairness to the accused with making sure that that is properly recognised. Involuntary lawful act, culpable homicide, is where the accused is doing something perfectly lawful and death results. Because McAngus and Kane has so clearly stated that for unlawful act, the act has to be directed against the victim, this means that some unlawful acts become part of lawful act, culpable homicide. So McAngus itself was about a statutory contravention. Sutherland was a case of fire raising to defraud insurers, which was not regarded as a crime against the person, so came into the lawful act category. The mens rea for this form is recklessness. Already had quite extensive discussion about recklessness. When I was looking at this, I came across many definitions of recklessness, many forms of words to describe it in Scots law. I think there are 8. They've all been referred to in homicide cases, even if they're not necessarily from homicide cases. I don't propose to read them all out. I think that might detain us too long. But patents, which is from a case of culpable homicide by driving, so this is at a very early stage in people having motor cars on the road, that was accepted for some time. There's subsequently in Transco been criticism of describing recklessness for the purposes of a criminal offence as criminal. It just goes round in a circle, and the word negligence has a particular meaning in the civil law, which makes it a bit problematic in the criminal law. Quinn against Cunningham was a case of riding a bicycle recklessly, and those definitions have had some currency in subsequent cases. Transco itself, very influential in relation to recklessness in Scots law. Again, critical of the patent definition, so boiling that down to gross or wicked indifference to consequences. W is a case where a 15-year-old boy dropped a bottle from the 15th floor of a block of flats and caused very serious injuries to a passer-by. Total indifference to and disregard for the safety of the public. Sutherland is the fire raising to defraud insurers case where somebody died and it went on to be a culpable homicide charge. So this brings us into the territory of risk, which is what recklessness is all about. McDowell is a road traffic case, part of which was about the accused having had a very serious road accident and then driving with his bonnet up so he couldn't see over the top of it. So that, again, talks about a complete disregard for potential dangers and the consequences. Transco, a degree of want of care which is grave. And Transco also establishes or states quite clearly that recklessness for this form of culpable homicide is a state of mind, which therefore brings us to the view that it's advertent recklessness, that the accused saw a risk and chose to disregard it. In other areas of Scots law, particularly in relation to driving, in Allen against Patterson, there'd been a view that it's about behaving in a particular way and then falling far below that standard. So the questions here, I think, are Is recklessness the appropriate dividing line between non-criminal and culpable homicide arising from a lawful act? I think it is expressive of doing something really terribly, and in order for the criminal law to be invoked, there should be that very severe drop below the standards that we expect. There's a lot of discussion about whether, if we keep recklessness, it should be subjective recklessness, the accused saw the risk and disregarded it, or objective risk, anybody would have seen the risk, it doesn't matter whether the accused did or not, we will criminalise on that basis. This is from an article by Finlay Stark, who, as most people know, has done a vast amount of research on recklessness. He tends to suggest that subjective and objective ties the discussion up in knots to some extent, and we should concentrate on the concepts of an utter disregard and indifference in terms of making people criminally liable. I don't want to say too much about this because Fiona's going to say a lot about it after lunch. Involuntary culpable homicide tends to, in terms of a mental element, use that of non-fatal crimes. So for unlawful act, there has to be an assault first, so that would be intention to cause immediate bodily harm, and lawful act uses recklessness. I just wonder whether that is an issue in art and part cases. So if the question in an art and part case is, did the accused commit murder or culpable homicide, that's probably fine. If the question is, however, did the accused commit assault or culpable homicide, how do we know what the common criminal purpose that that accused signed up to was if they did not inflict the fatal blow? To be convicted of assault on an individual basis, they would have caused death with the intention to cause immediate bodily harm. On an art and part basis, if it's not a murderous attack, how do we know whether the person who did inflict the blow is most fairly convicted of assault as opposed to culpable homicide? So, ways forward, its residual status, and if you ask first if it was murder, that might tend to suggest it's going to be tied up with anything that happens to the mens rea of murder. Possibilities are to retain the status quo, just keep the bipartite setup, have murder and culpable homicide. Look at restructuring culpable homicide into degrees. Lindsay wrote a very interesting commentary, sorry, putting on the spot here, on McAngus and Kane, which does tend to suggest that all we need is recklessness and we could just have one category, and if you assault somebody and they die, the chances are that that will have the quality of recklessness about it. And in relation specifically to voluntary, the partial defences are put into question as well. So that's it, thank you.